Hey out there, legal warriors. In this video, I'm going to cover 3 secret weapons that you need to know if you're ever trying to get a no contact order dropped. That can be a very frustrating experience, and these secret weapons will really help. So if you're interested in that area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. Now I'm just going to jump right into it. What do you mean by a no contact order in terms of this video, Lance? Well, what I mean is the standard domestic violence case that's a non-felony. It works for felonies too, but let's say a domestic violence assault 4th degree, harassment, malicious mischief. And the hypothetical situation I'm talking about here is that the alleged victim is wishing to have the no contact order terminated as part of a criminal case. What happens when the defendant, the suspect, gets arrested for a domestic violence crime in Washington state? And that's a very common occurrence. They get put in jail, typically, and then they'll see a judge, or even if they see a judge out of custody, the first time they see the judge, the prosecution almost always asks for a no contact order, which makes some sense to say the defendant can't contact the victim. And that's to try to protect the victim. And sometimes the victim doesn't want that. The incident might not have been very serious as far as DV incidents go. They might feel that the suspect is innocent. They might never have called the police. Sometimes they don't want their loved one away from them, and for good reasons. And we have to trust people's reasons, at least for purposes of this video. So in this video, I'm going to cover the 3 secret weapons for the alleged victim in trying to get the court or the prosecution, but the court decides to terminate a no contact order while that criminal case is going on. So what's the first secret weapon? Well, I think the alleged victim would be really wise to do what I call a safety plan. So the judge gets the final say whether or not there's a no contact order and how long it lasts. And so when we put ourselves in the judge's shoes, they want to try to protect who's listed as the victim from the defendant. And sometimes they substitute their judgment. Hey, even though you want the order dropped, alleged victim, I'm not going to do it because I don't trust you. You're not going to be safe. Well, plenty of domestic violence advocate agencies offer safety plans, which are a really good idea for someone who has been a victim of domestic violence. In general, a safety plan is something along the lines of, hey, who you're going to call if this order's dropped, who you're going to call if there's another problem. Do you have a bag packed and ready to go? Do you have some safe words you can text someone to let someone know something's going on? And so I'm no expert. It varies, and it's a very serious subject, but it's really important that if you're asking the court to trust you, you're asking the court to believe you're going to be safe, that you take some responsibility to help plan for your own safety. And it's never your responsibility that you're a victim, but if you want the court to listen to you, show them that you've thought about this and you've done a safety plan. So few people do that. And so it does carry a lot of weight when a judge says, hey, this alleged victim is so on the ball and so credible that they went out and did a safety plan. And most of the time you don't need to give the plan to the judge. It's usually done over the phone or something. You can just tell them you've done it, and then if they may ask questions, what it's about. But that's a secret weapon, and that could make the difference between having an order drop or not. What is secret weapon number 2? Well, secret weapon number 2 is the words that you use in addressing the court, in asking them to believe that your wishes should be honored regarding the no contact order that was put in place for your protection. It's so frustrating, and we represent alleged victims also, that grown adults aren't listened to about their wishes in certain cases. Now, we understand why. Their patterns of domestic violence would say that the alleged victim will often try to protect the abuser in these situations, and the abuser is supposedly presumed innocent, but in how it really works, it's not really what happens in court, in my opinion. Um, and so we could see why the court doesn't want to listen to people and why they want to try to protect their own selves so they don't make a mistake and something worse or something else bad happens to whoever the victim is in the case at hand. But so if the person asking for the order to be dropped in court sort of sounds like I love I love the defendant, I miss the defendant, stuff like that, it sort of can activate those protective qualities in the court. It's more important that the words you choose are powerful words. One thing that I've heard people say is, "Don't rob me of my agency." I'm more victimized if you take away my agency, judge, by not respecting my wishes, right? I'm These are the reasons why I want the order dropped. And state the reasons, but state them in an affirmative way, a powerful way. Do you have your own income? Are you financially dependent on the defendant? If you are financially dependent on the defendant, that's more reason you might ask for the order to be dropped and forego your own safety, right? Um, are you aware of prior acts where this has happened? If it's the first time that this has happened, maybe that also gives you a better chance to be heard and believed. And how is the order negatively affecting us, right? We can't take care of our kids because we have no other family around. We have no ability to go to work because of this. I don't know, but bottom line is the words you choose matter. So think about them, and you're trying to present yourself in an accurate way where you are a capable man or woman, whoever the protected party is, and that it's okay and it's safe for the court to believe that you know what you're doing and your wishes should be honored. Okay, so what is secret weapon number 3? And I could go with 2 things here, so I'm going to go with 3 and 3.5. Let's say the main third secret weapon is time. The sooner it is in time to when the offense happened, the less likely it is the court is going to drop a no contact order, because emotions are still fresh, emotions are still raw. It makes total logical sense that that's how the court would act, right? If it's a day after the incident, whatever happened that caused the incident, it's only a day later, how much has changed, right? And so as time passes, it's more likely the court may listen to what we want, okay? Also, along with that, if you get denied one time, it doesn't mean you can't ask again. So the second or third time, each time it's harder in theory for the court to deny a request because, they know they're taking a toll. The court wishes everything was happy. They don't want to interfere in people's lives. They don't want to keep people from doing what they want to do, but they also have a job to do because the defendant is accused of a crime. So what's 3.5? Well, 3.5 is try to find out from the defense attorney, if you can, has the defendant done anything? If the defendant's done some classes, anger management, DVMRT, that's domestic violence moral recognition therapy, that's pretty popular nowadays. They've done something, it's more likely the court can feel more comfortable in changing the original order to something new, because the court often says, oh, you want the order dropped, victim? Well, defendant, tell me what's different today than when I issued this order a month ago. Well, if the defendant can say, well, look, I've done these anger management classes, or look, I'm in counseling, look, I'm in DVMRT, I'm in alcohol treatment. Well, those are some reasons why the judge might feel more safe. And that's something that if you can know from talking to the attorney or finding out somehow without causing an order violation, that's going to give you a better position when asking the court to honor your wishes to terminate a no contact order. So, there's going to be a domestic violence advocate. You should probably talk to that person, but pay attention. Sometimes they may or may not. You may or may not feel like they're trying to do what you want. You may feel like they have their own agenda, or you may feel they're just doing things exactly as you want, communicating. Your mileage may vary, and we all have different opinions on that. But, if there's a victim's advocate you can talk to, you are allowed to talk to the defense counsel. You're allowed to talk to any treatment people to try to get information if you know anything. So what you want to do is use these secret weapons to try to get what you want to happen. That's why I'm putting out this video. Whether you should ask to have a draft or not, that's up to you. But this video is to help more people feel less helpless when asking the court to do what they want. So if you find this useful, please like and please subscribe. More people get the help they need. More importantly, if you have a legal problem, it's a criminal matter, feel free to reach out to my firm in Washington State. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.